Good morning.
Good morning.
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 Good morning.
Morning.
Good morning, everyone.
Good. What's your device? CCL2? Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the probate, guardianship, and civil docket for Thursday, February 26, 2026. The time is now 10:05. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter, who is also the court coordinator this morning. Video conference co-hosts this morning include Ms. Reyes, Mr. Lopez, Ms. Flores, Ms. Ramos, Ms. Cuellar, Ms. Hernandez, Ms. Lozano, and Ms. Rodriguez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez.
First in person, Counsel Joe Rubio. Page 3, number 6.
This is the estate of Jose Cardenas Jr., cause number 2022, PB 434L2. Mr. Rubio, go ahead.
Yes, Your Honor, I'm here on behalf of Luis Ricardo Cardenas, Your Honor. He should be online at Mr. Chito Davila's office.
Good morning, Mr. Davila.
Good morning, Your Honor. Can you hear me?
Sure can. The court marks you present by video conference. Who is this person to your right?
That is Beatriz Adriana Martinez, who is the mother of Luis Ricardo Cardenas, Your Honor.
Ms. Martinez, the court marks you present, participating by video conference from the office of Counsel Davila. Luis Cardenas, are you present?
He's present here in my office, Your Honor.
Court marks him present, participating by video conference from your office as well. Is there any other person at your office who will be making an appearance, Mr. Davila?
No, Your Honor.
All right, Mr. Davila, Mr. Rubio, what is the announcement?
Your Honor, we have filed a motion to release funds in the registry of the court. In the estate of Jose Luis Cardenas Jr., Luis Ricardo Cardenas inherited from his father the cash amount of $90,761.92. And on August the 22nd, 2024, Your Honor signed an order authorizing the county clerk to deposit these funds into an interest-bearing account. That the funds should not be released until the minor reached the age of 18. And he did reach the age of 18 on July the 24th, 2025. We're asking that the money be released along with any interest. We have always attached a certificate of birth, Your Honor, to the motion as Exhibit A.
Yeah.
Mr. Davila?
Your Honor, if whenever the court is ready, if Ms. Martinez can be sworn, we have a few direct questions to ask Ms. Martinez, Your Honor.
Ms. Martinez, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Sí.
Let's begin Spanish language interpretation now. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Jura o afirma que el testimonio que dará el día de hoy será la verdad bajo el amparo de Dios. Yes.
You may lower your hand, Mr. Davila.
Baje su mano y hable más fuerte.
Right. Ms. Martinez, will you tell the court your complete name?
Dígale
Beatriz
al
Adriana,
tribunal. Dígale al
Beatriz Adriana Martínez.
Ms. Martinez, either we're going to proceed all in English,
señora Martínez. Procederemos en inglés o
just wait until you hear the Spanish language translation, even though you may understand the English statement.
espere a que se traduzca lo que se le está diciendo al español, aunque usted comprenda lo que se le está diciendo en inglés.
Let's start again. Mr. Davila, go ahead.
Yes. Ms. Martinez, what is your complete name?
Señora Martínez, ¿cuál es su nombre completo?
Beatriz Adriana Martínez.
Beatriz Adriana Martínez.
And at what address do you live, Ms. Martinez?
¿En qué dirección vive usted, señora?
2401 Jerónimo Drive.
2401 San Jerónimo Drive.
Is that here in Laredo, Texas?
¿Eso es aquí en Laredo, Texas?
Sí.
Yes.
And who else lives with you at that address, Ms. Martinez?
¿Quién más vive con usted en esa dirección, señora?
Vive yo y mis 4 hijos, Luis Cárdenas, Víctor Cárdenas, Daleisa Cárdenas y Omar Cárdenas.
Myself and my 4 children, Luis Cárdenas, Víctor Cárdenas, and Daleisa Cárdenas,
Omar Cárdenas.
and Omar Cárdenas.
And the father of all 4 of your children is Jose Luis Cárdenas Jr., deceased. Is that correct?
Y el padre de todos estos 4 es el padre de estos menores, ¿correcto?
Sí.
Yes.
Now, during his lifetime, Mr. Martinez supported you and the 4 children. Is that correct?
Y durante su vida, el señor Martín Cárdenas le mantuvo a usted y a sus 4 hijos, ¿correcto?
José Luis Cárdenas, sí.
Yes, José Luis Cárdenas, yes.
And Mr. Cárdenas' estate left an inheritance of approximately $90,000 to each of your 4 children. Is that correct?
Y él les dejó en bienes aproximadamente a cada uno de los menores $90,000, ¿correcto?
Sí.
Yes.
And when Mr. Cárdenas passed away several years ago, all 4 of the children were minors. So you deposited their respective funds in an interest-bearing account until they each reached the age of 18. Is that correct?
Y cuando falleció el señor José Luis Cárdenas, los 4 eran menores de edad y usted depositó los fondos de los bienes en una cuenta de intereses, ¿correcto?
Sí.
Yes.
Now, the oldest child, Luis Ricardo Cárdenas, he turned 18 on July 24th, 2025. Is that correct?
Y es correcto que el mayor Luis Ricardo Cárdenas cumplió la edad de 18 años el día 24 de julio de 2025, ¿correcto?
Sí.
Yes.
You have lived and cared for all 4 children since their birth, including Luis Ricardo Cárdenas, who is autistic. Is that correct?
Y usted ha cuidado a todos los menores desde que ellos nacieron. Usted ha cuidado a Luis Ricardo Cárdenas desde su nacimiento debido a que él es autista, ¿correcto?
Sí.
Yes.
And you are here today requesting that the court release his funds now that he is 18 years old, and that the funds of the other 3 children, who are still minors, continue in the registry of the court until they turn 18 years of age, correct?
Y usted le está pidiendo a este tribunal que libere los fondos del hijo mayor de 18 años y que los fondos de los 3 hijos menores sigan bajo el registro del tribunal, ¿correcto?
Sí.
Yes.
We have nothing further, Your Honor.
Anything on cross, Mr. Rubio?
No, I'm aligned with Mr. Davila, Your Honor.
And I just need to ask, so we can have it on the record if,
Yes, sir. I'm the one who filed the motion.
Right. I just want to give everybody an opportunity
Yes, Your Honor,
to.
we're just asking that now that Luis Ricardo Cardenas has reached the age of 18, that the funds now can be released.
Let me hear the translation.
Solamente estaremos pidiendo al tribunal, su señoría, que debido a que él ya cumplió 18 años, que se liberen los fondos.
Your Honor, if I may, the order does not have the 5% administrative fee.
Su señoría, si me permite, la orden no incluye el pago administrativo del 5%.
I was about to address that, but
I'm sorry, the payment of what?
give me 1 second.
Payment to
Is
the-
there any other person here that would like to be heard on this matter? I know that there's one other person at your office.
No, Your Honor, for the record, we have touched base with, I'm really helping Mr. Rubio because he was in a trial and we didn't know, if he would be able to get away or not. But we have touched base with, Oscar Vela, who was appointed, attorney ad litem by the court when the, administration of Jose Luis Cardenas Jr. deceased was, being processed. He has no objection to the motion filed. We also touched base with Mr. Romero, who represented some of the other children, and he has no objection, Your Honor. So it's an unopposed motion, Your Honor.
All right, so let me do this on the record. No need to interpret. We're not testimony anymore. Cause number 2022 PB 434L2. The court has received, reviewed, and considered the motion to release funds in the registry of the court. The court has now also heard the testimony of mother Beatriz Adriana Martinez. The court finds that there is good cause, reason, and basis to grant the request. The court hereby grants the request and will order $90,761.92, which is the amount in the registry of the court held, I guess, in trust for Luis Ricardo Cardenas. And I've signed an order to that effect. However, the county clerk's office is going to require specific language that allows them to withhold or keep the administrative charge that they normally do. Let me ask the clerk's office, what language would suffice to release that money?
Just anything having to say it's a 5%, not to exceed $50.
And that goes to the county clerk, or
It's administrative fee.
I wonder if we could write that in the order, like, I would. That 5% or and up to $50 be.
Let me give you an order to write that in. And then hand that order with that language to the clerk's office so that we can inquire if that language is sufficient.
And while that's being done, Your Honor, it does not need to be in the order, but I take it that the similar funds that are on deposit for the other three children who are still minors will continue in the registry of the court until an appropriate motion is filed at the appropriate time, correct?
Correct. I think we should do this. So as soon as that order is written in, presented to the clerk, we get confirmation that the clerk, that the language is sufficient. Let me ask you this, Mr. Davila, is there any pending relief that needs to be considered by the court?
Nothing other than the release of the funds of the particular oldest child who has reached 18, Your Honor.
And Mr. Rubio, once the court signs this order, is there any pending request for relief?
Not at the present time for the other children. We're gonna wait till they reach the age of 18. I think the The next, the next child that reaches 18 will be in November.
Right. All right. Let me ask the clerk's office. Mr. Rubio has written in. I think you should initial it.
Okay.
Yeah.
Well, I thought that maybe you were going to be signing under it. I didn't want to
Sure. No,
be
but
presumptuous. you know.
sure. I appreciate that. Let me ask the clerk's office. Have you been given an opportunity to review the language written in now by Mr. Rubio?
Yes, Your Honor.
Does that language suffice to release the funds?
Yes, Your Honor.
Fantastic. The court has signed that order to release funds in the registry of the court with the additional language. The court is tendering the original to the clerk's office. And now the court is going to, now that that's taken place, the court is going to prepare its own order, Mr. Lopez, setting this case to inactive pending any other request for relief or any other further orders by the court.
Yes, Your Honor. We probably will be back here in November.
Very well.
Yes, sir.
Ms. Martin, do you have any questions for the court?
Que si tengo preguntas, no.
That if I have any questions, no.
Anything else on this case, Mr. Davila?
No, Your Honor, we thank the court and may we be excused, Your Honor.
Yes, sir. Have a great day. Any other cases for Mr. Rubio?
No, Your Honor, neither for Counsel Davila.
Good to see you both. Have a great day.
Same here, Your Honor. May I be excused?
Yes, sir.
Thank you.
Thank you, Judge.
Yes, sir.
Next in person, Counsel Luis Antonio Figueroa, page 4, number 9.
This is the estate of Fabian Garcia, cause number 2024 PB 779L2. Good morning, Mr. Figueroa.
Morning, Judge.
Court marks you present in person. Maria Garcia Silva, are you present?
She's present, Your Honor. She needs interpreting. The one before the court is Marta Garcia, Your Honor. There-
Right, I haven't asked you yet. Give me 1 second. I need you to unmute your device, Ms. Silva.
Señora Silva, por favor, active su micrófono.
Okay. Okay.
Are you Maria Garcia Silva?
Sí.
Yes.
Court marks you present participating by video conference.
Tribunal marca presente por medio de videoconferencia.
As you can see and hear from your device, your lawyer is present in person.
Como usted puede
Yes,
ver,
I saw him.
Ms. Silva, would you like an interpreter or would you like to continue in English?
English.
All right. We will forego interpretation on this case. Speak into the microphone and tell the court your name, please.
Marta García Silva.
Welcome to court, Ms. Silva. The court marks you present in person. You may lower your hands.
baje sus manos, por favor.
Okay.
Would you like to continue in English or do you need Spanish language interpretation? Well, okay, so
Pero
here,
español, por favor, no me quiero equivocar cuando conteste.
I prefer Spanish so that I don't make a mistake when I answer.
Mr. Figueroa, what is Marta Silva's relationship to this case?
She's the daughter of the decedent. All three of them are daughters.
¿Cuál es la relación de la señora Marta en este caso? Ella es hija del fallecido, su señoría. Todos son hijas del fallecido.
The court welcomes everyone to court.
El tribunal le da la bienvenida a todas.
Mr. Figueroa, what is the announcement?
Judge, we're ready to proceed. I believe everything is complied with. We're ready to proceed in our amended motion to probate the wills of minimum time. Based on.
Let me hear the translation.
Estamos listos para proceder en nuestra aplicación enmendada para las letras testamentarias del día de hoy.
Ms. Silva and Ms. Silva, I'm going to ask that you both raise your right hands.
Les pido a ambas que levanten su mano derecha.
Do you and each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God?
Cada una de ustedes acuerda decir la verdad, toda la verdad y nada más que la verdad bajo el amparo de Dios.
Sí.
Yes.
Ms. Silva, participating by video conference, you haven't responded. Turn on your microphone once more.
Yes.
Right, you may lower your hand. Ms. Silva, who is the other person with you in the room?
Are you asking me?
Yes.
No, this is my daughter, but she's not participating in this.
No, she is, because she just appeared before the court on camera. So one more time, who all is with you in the room?
My daughter,
All right. And what is your daughter's name?
Mónica Leticia Lerma.
Ms. Lerma, welcome to court. The court marks you present, also by video conference. Mr. Figueroa, who is your first witness?
I called Marta Garcia Silva, who is present before the court.
All right. We'll begin Spanish language interpretation now. You may proceed.
Please state your name for the record.
Por favor, diga su nombre para el récord.
Marta D. García Silva.
Marta D. García Silva.
And Fabian Garcia was your father, and he died August 13th, 2024 at the age of 91. Is that correct?
Y el señor Fabián García era su padre y él falleció el 13 de agosto de 2024 a la edad de 90 años, ¿correcto?
Correcto.
Correct.
Your father was domiciled here in Webb County, Laredo, Texas, at the address of 1309 Convent Avenue.
Y él estaba domiciliado aquí en Laredo, Texas, en el condado de Webb, en 1309 Convent, ¿correcto?
Correcto.
Correct.
Your father was of sound mind when he executed his holographic will, is that correct?
Es correcto que él era de mente sana cuando él ejecutó este testamento bajo puño y letra.
Correcto.
Correct.
And the will talks about giving all property to all three of you, which are daughters of Mr. Fabian Garcia, correct?
Y este testamento dicta que los bienes raíces deberán de ser distribuidos dentro de las tres hijas, ¿correcto?
Correcto.
Correct.
Correcto. Correcto.
And as far as you know, this will was never revoked.
Y en cuanto usted sepa o lo que usted a su conocimiento, este testamento nunca fue revocado.
No.
No.
And also there's no contest or objection to the probate of this will.
Y no hay oposición o objeción a que se interponga esto ante el Tribunal de Ley Testamentaria.
No.
Is it correct that at the time of your father's death, there was no debts secured by real estate, or any other type of debt in this case?
Y es correcto que al momento que su padre falleció no haya adeudos en cuanto a bienes raíces que se refieran a este caso.
No.
And there is no lien for Medicaid or Medicare at this time, correct?
Y no hay adeudos hacia Medicaid o Medicare en este momento, ¿correcto?
No.
And the will does not name the state of Texas or any other charitable organization as an heir or DIC.
Y es correcto que este testamento no nombra al estado de Texas o ninguna organización de caridad como heredero.
No.
And you're asking this court that this court grant the probate of this will as a meaning of title, is that correct?
Y usted le está pidiendo a este tribunal que otorgue la aplicación y la petición en cuanto a ley testamentaria, ¿correcto?
Correcto.
Correct.
That is correct. That's all we have, Judge. We need to execute the proof of death and other facts and oath, I believe. That's the part that.
Parece mamá de lejos.
One question, Mr. Figueroa. The court didn't hear any testimony as to the authenticity of the signatures on the holographic will, but I do see that there is an affidavit of witnesses filed into the case. Are you asking the court to take judicial notice of the entire case file?
Yes, Your Honor, thank you.
Anything else on this case?
Nothing further, just to execute those documents. And we have a proposed order that I have in my possession. We can hand it to Your Honor, or we can file it.
And this is, what you're specifically asking for is to admit the will and,
At the minimum time.
all right,
Your Honor, the witness before you is the co-applicant in the amended application. And as the main applicant, Ms. Maria Garcia Silva, who is joining us online.
right. That's clear to the court. All right, Ms. Silva, in your father's case, cause number 2024 PB 779L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider this matter. The court has and hereby takes judicial notice of the entire case file, which includes the application for this holographic will, the affidavit of the witnesses regarding that signature, the abstract in the case, the original death certificate, the citation by posting, the waiver of citation for the other errors, and this application to probate this holographic will. The court has heard sufficient information and testimony in the record to grant the request. The court hereby admits this will as a muniment of title. All right, you can sign those documents.
Proposed order, Your Honor. Do you have it open?
The court has received, reviewed, and considered the proposed order admitting this holographic will to probate as muniment of title. It is in due form. The court has signed it and tendering the original to the clerk's office.
If we're submitting the proof of death and other facts and the oath of
All right, anything else on this case, Mr. Fierro?
Nothing further, Your Honor.
Ms. Maria Silva, do you have any questions for the court?
No, sir.
Ms.
Everything is fine.
Say that again.
Everything is fine.
Thank you. Ms. Marta Silva, do you have any questions?
No, todo está bien.
Everything is fine.
I wish you both very well, and you have the court's condolences. Have a good day.
Thank you.
Thank you.
There
Thank you.
are matters before the corporate counsel Figueroa this morning.
Good to see you, counsel. Have a great day.
Thank you, Judge.
Next in person is Council Notson and Council Sergio Perez on page 9, number 19.
This is Tanya Elizabeth San Miguel versus Alberto Pina, cause number 2011 CVG 2217C3. Court marks Mr. Perez present in person, Mr. Notson also present in person. Tanya San Miguel, Alberto Pina, is any party present?
They're not present, Your Honor.
Court finds no parties are present. This is a calendar call, Mr. Perez, Mr. Notson. Anything for the court to consider?
No, Your Honor, just that I think the visitation is going well. I talked to Mr. Perez about a final resolution. And so we're going to talk to our respective clients about that, and we'll advise the court if we have an agreement and an entry of judgment date.
Mr. Perez?
That's correct, Your Honor.
All right. Well, the purpose of the calendar call was for that. We already have a scheduling order in place, a final pretrial on March 31st at 2, and a final hearing on April 28th at 2. And I just needed to hear from each and all whether there's anything that the court can do at this juncture to facilitate your negotiations or anything that any party wanted to be heard on. If there isn't, then we'll go forward with a final pretrial hearing March 31st at 2. Anything else for the court to consider, Mr. Perez?
Nothing, Your Honor.
Mr. Notson?
No, Your Honor.
Any other cases for either counsel?
No, Your Honor.
It's good to see you both. Have a great day.
Thank you.
Have a good day.
Yes, sir.
Next in person is Council Nathan Chu, page 5, number 10.
Maria Isabel Rodriguez versus San Francisco Real Properties LTD, cause number 2024 CBD 8602. Court marks Mr. Chu present in person. Good morning.
Good morning, Judge Nathan Chu, present for San Francisco Property Management LTD.
Welcome to court. The court marks Mr. Rene Benavides present and participating by video conference. Good morning, counsel.
Device identified.
Court is asking Mr. Benavides to start video and unmute electronically now. Court marks Mr. Benavides' device logged in. Are you Isabel Rodriguez?
Yes, sir.
Welcome to court, Ms. Rodriguez. The court marks you present and participating by video conference. As you may see, your lawyer's device is logged in.
Yes,
Is-
he is logged in. I'm sorry.
Yes,
Judge.
John.
Okay.
Good morning, Mr. Benavides. The court marks you present and participating by video conference. Your client is also present and participating by video conference. Anybody else here on or making an appearance for San Francisco Real Properties other than Mr. Chu? Please step forward. Speak into the microphone and tell the court your name.
Martina Margarita Frescas Ángel.
One more time, a little bit louder and slower.
Martina Margarita Frescas Ángel.
Ms. Ángel, welcome to court. The court marks you present in person. The person to your left is San Francisco Real Properties LTD's lawyer. Mr. Chu, Mr. Benavides, this is a bench trial. What is the announcement?
We're ready to proceed, Judge.
You're on mute, Mr. Benavides.
Yes, Your Honor, we're ready.
All right. So I'm going to mark this as the first contested matter on the court's docket this morning. Several questions. Let me get some background facts before I put this case on pause and continue calling the rest of the docket. This is an appeal from a Justice of the Peace Court case.
Yes, Your Honor.
Who was the plaintiff in that case?
The plaintiff, Maria Isabel Rodriguez.
All right. And the Justice of the Peace made a finding and issued an order awarding what to whom?
The Justice of the Peace denied our request, so didn't award anything to the plaintiff. It was a judgment of the defendant.
And I'm assuming it's the same thing, but at that juncture, at that hearing, what was your client seeking?
Yes, Your Honor. My client was seeking recovery of the security deposit withheld from the apartment under the property code, making a claim under 92.109 of the property code. In addition to that, was seeking some damages that are allowed when there is withheld, or when there's money withheld in bad faith, which includes 3 times the amount of the amount withheld, $100 fee, and attorney's fees. The judge denied all requests. And just a little background, there was a security deposit of $1,500 from a lease of 1 year. There was a certain amount withheld, not the entire amount. It was $773.98 that was withheld. And we just argued that that was withheld improperly.
Without telling the court whether that legal position is right, Mr. Chu, is that your understanding of the background facts?
Yes, Judge.
All right. That frames this this situation in this case for the court. I just need to ask from both of you, because I reviewed for today's hearing by looking at the docket and looking at the case management system, but I didn't on this case go into case center or case lines. Ostensibly, Mr. Benavides and Mr. Chu, any evidence that you present has already been uploaded 24 hours in advance into case center?
Yes, Judge. We uploaded the invoice and pictures of the damaged items that my client had to fix.
Mr. Benavides?
I did upload it, Your Honor. It was not done 24 hours in advance, but I did upload the system.
Well, it should have been 24 in advance. Any objection, Mr. Chu?
No objection, Judge.
All right, so without objection, we will proceed momentarily. All right, if you can, if it helps, talk to each other, but I know you're at this juncture already, so I'll call this case momentarily and you'll proceed.
Thank you.
First online is counsel Nelly Salazar.
Page 1, case 1, the estate of Maria Guadalupe Lopez, cause number 2022 PB 4109L2. Good morning, Ms. Salazar.
Good morning, Your Honor.
Court marks you present and participating by video conference. Mr. Jose Luis Castillo or Patricia Garcia, are you present?
Yes, I'm here, Patricia Garcia.
Please start your video, Ms. Garcia.
Yes.
Are you Patricia Garcia?
Yes, Patricia Garcia.
Welcome to court. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer, Ms. Salazar, is also present and participating by video conference. Ms. Garcia, who is the person on your right?
Maria Reyes,
And what is her relationship to you?
sister.
Welcome to court, Ms. Reyes. The court marks you present before the court. Mr. Lopez, I'm going to ask that you unmute your device. It's pretty clear now to the court, Mr. Lopez, that your device is frozen. If you can hear me, Mr. Lopez, unmute your device. Ms. Salazar, what is Mr. Lopez's relationship to this case, if you know?
Yes, Your Honor, I believe he is an interested party. He's one of the heirs in this case that has a property interest that's subject to the lawsuit.
The court marks his device logged in. He is no longer audible or visible. Ms. Garcia, is there any other person present with you in that room?
Yes, Roberto Lopez, brother.
Welcome to court, Mr. Lopez. Anybody else?
And Maria Lopez, his wife.
Welcome to court, Ms. Lopez. Anybody else?
And that's it.
All right, Ms. Salazar, what is the announcement?
Yes, Your Honor. So we're set today for a status. I was just going to announce to the court that the parties did attend a mediation in February, but they were not able to come to a full agreement. Only one of the heirs deeded their property interest. The other heirs, the remaining 6 heirs, they still do not know what to do with their property interest, and they haven't come to an agreement. So for that reason, I was going to request from the court maybe another a hearing date, because it looks like this will probably necessitate a hearing.
Well, it looks like you're already scheduled for a hearing on April the 7th at 2. So Ms. Reyes, Ms. Lopez, and Mr. Lopez, you're going to come back to court. And if you don't have an agreement, the court will hear some evidence and testimony and make a decision for you. Although between now and then, you're certainly free and welcome to talk to each other to see what, if any, agreement you can reach. Ms. Reyes, do you have any questions for the court?
Well, as a family, we did come to an accord, but Patricia Garcia she does not agree with what we are putting out as an agreement.
Well,
So I don't know what we're gonna get at.
Well, I understand that, but if you don't agree, then I'll make a decision for you on April the 7th. Right. So, but my question here right now is, do you have any questions that I can help answer? All right.
No, not right now.
All right. Mr. Lopez, same question to you. Do you have any questions, Mr. Lopez?
No.
All right. Is there any other person present on this case? All right.
Your Honor, may this final hearing be held all parties present in the courtroom?
Yeah, I think that's a good idea because there's clearly background noise for persons that haven't been identified. All right, I'm going to order that this case be held in person for all persons that would like to be heard on this case. This is scheduled for April the 7th at 2 p.m. Is there any objection to any of this by any person? All right, so ordered.
No.
without objection. Ms. Salazar, anything else on this case?
Yes, Your Honor, I do have one more case before the court. It is in the interest of Luis Soto, cause number
All right, give
2025.
me 1 second. Everybody on this case is currently excused. We'll see you on April the 7th. Ms. Rodriguez?
Next case for council, number 8.
This is in the interest of LES and LS, cause number 2025 PBA 2802. Court marks Ms. Nelly Salazar present and participating by video conference. Are you Denise Ramos?
Sí. Yes.
Welcome to court.
Bienvenida al tribunal.
Court marks you present by video conference.
El tribunal les da la bienvenida y le marca presente de videoconferencia
As is your lawyer.
en conjunto con su abogado.
Ms. Salazar, 1 sentence at a time.
Yes, Your Honor, and I apologize, my feed is cutting in and out. Can you guys hear me okay?
Yes.
Yes, Your Honor. So yes, we're here today just to give a court a brief background on this case. So Ms. Ramos is a mother of two, at the time, 2 minors. She filed an application to sell the minors' properties without a guardianship. Under the Texas State Code, she followed all the requirements. Once the property was sold, she put those sales proceeds into the court registry. So now she is requesting that for one of her sons, who is the remaining minor, that those sales proceeds. Oh, I'm sorry. I'm so sorry. I'm sure there's an interpreter. If you want, I could go.
No, we're just going to forego all of that. Just we'll just go straight into testimony for translation. But go ahead and make whatever thoughts, comments, and arguments you want. Go ahead.
Yes, I apologize. But yeah, long story short, though, we do have the funds in the court registry. It is in an interest-bearing account, but Ms. Ramos feels she did some research on CDs, on certificate deposits, and she feels like the sales proceeds for the remaining minor child in this case would benefit more if it was put into a CD. So she's requesting the court if they can make that change.
Well, and it looks like Ms. Salazar, that the specific request is to specifically deposit these funds into a certificate of deposit, and that's what's written into the order. In other words, you're not saying, take this money and I'll see what I do with it. I'm going to tell you, but you're specifically asking that the court order that happen.
Yes, Your Honor.
All right, Ms. Ramos, would you raise your right hand, please?
Ramos, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God.
Afirma que el testimonio que dará ante esta causa será la verdad bajo el amparo de Dios.
Sí.
Yes.
You may lower your hand. Ms. Salazar, go ahead.
Ms. Ramos, can you please state your name for the record?
Por favor, diga su nombre para el récord.
Denise Vanessa Ramos.
Denise Vanessa Ramos.
And Ms. Ramos, you filed an application to sell a minor's property without guardianship for Leonardo Soto and Luis Eduardo Soto, your sons.
Usted
Correct?
puso una aplicación para vender los bienes reales de los menores, ¿correcto?
Sí.
Yes.
And that application allowed you to sell your minor children's interest in real property, correct?
Y esa aplicación le otorgó a usted la oportunidad de vender los intereses sobre sus bienes reales de los menores, ¿correcto?
Sí.
Yes.
And that application also required that the sales proceeds be deposited in the court registry, correct?
Y esa aplicación requirió que cualquier ganancia de esa venta haya sido depositada en el registro del tribunal, ¿correcto?
Sí.
Yes.
And the sales proceeds for both of your minor children were indeed deposited into the court registry, correct?
Y esas ganancias fueron de hecho puestas en el registro del tribunal, ¿correcto?
Sí.
Yes.
And are you requesting from the court today to place Luis Eduardo Soto's 25% interest share of the sales proceeds in a certificate deposit as opposed to the court registry?
Y usted está pidiendo a este tribunal que se le otorgue la petición de poner el 25% del interés de Luis Eduardo Soto en un CD en vez de estar en el registro del tribunal.
Sería Leonardo Soto.
It would be
Oh.
Leonardo Soto.
Yes.
Sí,
Yes.
Yes, and just to confirm, this is for your son Leonardo Soto, who's a minor, correct?
Y para confirmar, esto es para el menor Leonardo Soto, ¿correcto?
correcto.
Correct.
And why are you requesting this from the court today?
¿Y por qué es que usted está pidiendo esto del tribunal el día de hoy?
Con la finalidad de que se aprovechen al máximo los recursos que se van a utilizar para sus estudios y su educación de la universidad en un futuro.
With the finality of maximizing the resources in order to cover the education in the future.
And Ms. Ramos, you believe that by putting the sales proceeds into a CD or certificate deposit, that it will yield a higher return in the long run, correct?
Yes, ¿usted cree que al interponer estas ganancias en un CD le dará a usted un mejor retorno, correcto?
Sí,
Yes.
And have you chosen a certificate deposit from Vantage Bank?
¿Y usted ha ya seleccionado un depósito certificado en Vantage Bank?
sí.
Yes.
And what are the terms of this certificate deposit?
¿Y cuáles son los términos de este depósito?
12 meses al 2.75 APY.
12 months at 2.75 APY.
And what are your plans when the certificate deposit expires in 12 months from now?
¿Y cuál es su plan una vez que ese certificado se expire en 12 meses?
Que se renueve solo.
For it to auto-renew.
And are you willing to return to this court 2 months before the expiration of the certificate deposit in order to receive approval for reinvestment?
¿Usted está dispuesta a regresar a este tribunal en 2 meses para que le otorgue aprobación de volver a entrar en ese acuerdo por otros 12 meses?
Sí,
Yes.
Are you willing to waive the right to withdraw the sale proceeds from the certificate deposit without prior court approval until your son reaches the age of majority or is otherwise emancipated?
Y usted está poniendo a un lado su derecho para requerir la aprobación del tribunal para remover esos dineros hasta que su hijo sea emancipado o cumpla la edad de 18 años.
sí.
Yes.
And do you believe that putting the sales proceeds in a Vantage Bank certificate deposit with the terms you previously listed is for the best benefit of the minor in this case?
¿Y usted cree que al poner estos dineros Vantage Bank en ese CD está en el mejor interés del menor?
Sí.
Yes.
That's all the questions I had, Your Honor.
Just a couple of questions, Ms. Ramos. When does Leonardo turn 18?
Un par de preguntas. ¿Cuándo cumple 18 años Leonardo?
En diciembre 15, dentro de 4 años, pues el 2029.
December the 15th, in 4 years' time, 2029.
Right then. The court has heard sufficient information in the record to grant the request. It is hereby granted.
El tribunal ha escuchado suficiente evidencia ante el récord y se otorga su petición.
Court is and has signed the order to deposit these proceeds into a certificate of deposit.
El tribunal ha firmado la orden para poner estos dineros dentro del depósito.
And the court is going to order 3 hearings because this requires that Ms. Ramos provide an annual accounting.
Y el tribunal pondrá las audiencias porque esta petición ahora necesita que interponga 3 reportes anuales de contabilidad.
We'll come back in 2027, 2028, and 2029.
Estaremos en el 2027, en el 2028 y en el 2029.
Court has granted your request, Ms. Ramos. I am tendering the signed order to the clerk's office.
Se otorga la orden firmada a la oficina de la Secretaría del Condado.
Do you have any questions for the court?
¿Alguna pregunta para este?
Ninguna, gracias.
None.
I wish you and your family well. Have a good day.
Deseamos el bien de su familia.
Any other cases for Ms. Soto or Ms. Salazar? Have a great day. It's good to see you.
Thank you, Your Honor. Have a good day.
Next online is Counsel Raúl de la Garza, page 5, number 12.
Mario Alfonso Tejerina Jr. versus Homesite Insurance Company, cause number 2025 CVF 63L2. Welcome to court, Mr. De La Garza.
Good morning, Your Honor.
Court martial present and participating by video conference. George Jackson, Counsel Jackson, are you present? Is anybody here representing Homesite Insurance Company? Court finds that no person is. Mario Tejerina, are you present? Court finds no parties are present. Mr. De La Garza, go ahead.
Yes, Your Honor. Good morning. We recently settled this case with former Chief Justice Dory Contreras. I know that Your Honor said that if we had settled, that we didn't have to appear, but yesterday we called the court and they asked us just to announce it. So out of an abundance of caution, here we are.
Well, I appreciate that, Mr. De La Garza. So since you've settled, will you be filing a judgment or a non-suit?
Yes, Your Honor. If we can have about 45 days for that, please.
All right, give us an orders due date in 45 to 60 days, please.
Checking our April date, Your Honor.
Sure.
That would be April 27th by noon by submission.
All right, so just get it in before that date. If it is, I will sign off on it and that will conclude this case. I appreciate you and Mr. Jackson's effort, and as always, Chief Justice Dory Contreras. Any other cases for Mr. De La Garza?
No, Your Honor.
It's good to see you, counsel. Have a good day.
Likewise, Your Honor. Have a good one. Bye-bye.
Counsel Tammy Wincott, page 2, number 5.
This is the estate of Jacqueline Talley, cause number 2025 PB 771L2. Welcome to court, Counsel Wincott.
Thank you, Your Honor.
Court marks you present and participating by video conference. Are you Larry Talley?
Yes, I am.
Welcome to court, Mr. Talley. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Counsel Wincott, what is the announcement?
Your Honor, I'd like to point out to the court that I had filed a motion for continuance in this case because I had a hearing prior to this in Medina County, where I'm sitting now. But I was able to obviously make this hearing. So if you would, I don't know if you signed that order or not, but if you did, please vacate it. If we could go forward in this case.
Sure. The court is setting this motion for continuance aside. This case is ready. Counsel, Ms. Wincott, are you announcing ready?
I am announcing ready, Your Honor, yes.
All right. I certainly appreciate the ability and the diligence to juggle multiple things and cases in one day. Mr. Talley, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
You may lower your hand. Counsel, go ahead.
Your Honor, if you would take judicial notice of the documents in the file, there are original authenticated copies of the order from Washington State admitting the original will to Washington State, along with a copy of that will. You have a copy of letters, or rather you should have the letters testamentary and original death certificate. the proof of death has been signed and filed, and there is a resident agent on file for Mr. Talley.
All right. What else? Anything else?
I think that's all I need you to take judicial notice of. We're requesting that the ancillary probate take place and that this will be admitted to Webb County as an ancillary probate, but we're needing Mr. Talley to be issued letters testamentary for the ancillary probate because there is a need for administration of this estate. Are you, quite honestly, this is the first time I've needed to get letters testamentary for an ancillary probate. Are you needing me to do the proof for Mr. Talley?
Well, I certainly need you to put sufficient information in the record to allow the court to honor that request. So if you feel fine as is, if not, if you want to elicit any testimony from Mr. Talley, you're certainly welcome to do so.
I'll ask him the proof, that way he can get appointed.
Sure.
Mr. Talley, when you're ready.
I'm ready.
Okay, would you please state your full name for the court?
Larry Rex Talley.
All right. And are you currently the independent representative of the estate of Jacqueline Berlin Talley in Washington State?
I am.
Okay. Are you also the trustee of the My Three Sons Trust?
I am.
I think it's all my, okay, that's the one mentioned in the will, correct?
That's correct. My Three Sons Living Trust.
Okay, thank you. And Jacqueline Berlin Talley passed away on April 22nd, 2025?
Correct.
All right, and her domicile is the state of Washington, but she does own real property in Webb County, is that correct?
That's correct.
Please re-ask that last question one more time. You cut out.
Oh, have you ever been convicted of a felony?
No.
Okay. And is the state of Texas an agency of the state or a charitable organization named in the will as a beneficiary?
No.
Okay. I'm sorry, Your Honor. I think there are church bells going off in the background. And a necessity does exist for the administration of this estate?
Yes.
Okay. And are you asking that this court grant you letters testamentary and appoint you as the personal representative without bond in this estate of Jacqueline Berlin Talley?
Yes.
Counsel, I hope we haven't lost you or that you're frozen. Give Ms. Wincott a minute or two to become unfrozen.
Device no longer in virtual while relevant.
Yes, the clerk's office, is there a proposed order on file? Do you have that order?
Yes,
The proposed order is an order signing for the state of Washington and for some other court. Is there a proposed order for this court? All right. So let me do this, Mr. Talley, because although your lawyer is no longer, we're admitting that device now. Ms. Wincott, we lost you for a few minutes. I'm going to ask that you unmute your device and you start your video once more. Please unmute your device.
Your Honor, were you speaking to me?
Yes. All right. Well, you're back.
Sorry.
Ms. Wincott, the court marks you present once more. As I was telling Mr. Talley, in this case, cause number 2025 PB 771L2, the court hereby takes judicial notice of the entire case file. The court finds that it has jurisdiction over this case. The court finds, having taken judicial notice, that there is an original death certificate, a distributee's agreement for ancillary independent administration with the power of sale and waivers of citation and notices thereto, including the application to probate this foreign will, the appointment of a registered agent, the addendum qualification to serve as independent executor. The court also now has heard your testimony here today. The court finds that you are entitled to the relief that you are requesting. The court will cause letters of, the court finds that there is a necessity to administer this estate. The court will cause letters of testamentary to be issued out to you, and you are to serve without bond. These are the orders of the court, and these orders have been filed.
Your Honor, would you like a due date for the executed oath?
Yes.
Would March 30th, before March 30th be good? On or before March 30th?
Any objection to that date, Ms. Wincott?
No, not at all. That's fine.
Let me just review this order that you filed.
And I'm sorry, Your Honor, apparently my iPhone overheated. So the background noise now is the AC cooling the iPhone down.
Well taken. The court has signed that order. It is in due form, and hopefully you can get the proof of death and all the other requirements in within 10 days. But in any event, we're going to put a schedule so that they're definitively due before March the 30th. But as soon as they come in, they'll be approved. Mr. Talley, do you have any questions for the court?
No.
Ms. Wincott, anything else on this case?
No, Your Honor, that's it. Thank you for your patience.
All right, Mr. Talley, you have the court's condolences. Good luck to you. Ms. Wincott, good luck and safe travels.
Thank you, Your Honor.
Thank you, Your Honor.
In person, counsel Jose Reyes II, page 1, number 2 and 3.
There are two cases. They're not together or consolidated, but they are companion cases. This is the estate of Francisco Galarza III, cause number 2023 PB4 84L2, and the estate of Linda Galarza, cause number 2023 PB4 8702. Court marks Mr. Reyes present in person. Mr. Villafranca, are you present?
Not present or identified.
Court marks Mr. Villafranca not present. Mr. Julio Garcia, are you present? Court finds Mr. Garcia not present. Leticia Lizette Peña, are you present?
Not present or identified.
Court finds no other persons are present. Mr. Diaz?
You're on the God, my voice is terrible. I'm sorry, Judge. We set this case up because we were already on the 84 case, which is Francisco Galarza. We've been at inventory. We haven't finalize the proposed order. Mr. Villafranca, one of the holdups was that the court was requesting an order from the ad litem or the ad litem's report. Mr. Villafranca, and it's in the entries of the minutes where Mr. Villafranca appeared and he testified as far as he gave an oral report. I want to say, I have it here, on September 17th of 2024. And what I can do is I can prepare one for him on both cases. I have all the documents that are pending. I need like the waiver of service, the bond, proof of death. I just need a final hearing because the two disinterested witnesses, which would be on both 84 and 87, are elderly and they make special accommodations. And if we try to do it via Zoom, it'll take 40 minutes. I've had meetings with them via Zoom and it's just not productive. One of the disinterested witnesses is extremely hard of hearing. And so I'd rather just set a date, a concrete date, so I can e-file everything and then have them physically come in the court so we can dispose of both matters.
I think that's a good idea because in the court's review of the case, it wasn't clear to the court. Well, it's clear to the court that Mr. Villafranca hasn't filed a written report, but it wasn't clear to the court by looking at the record who the heirs are. Do you know what his oral report on September the 17th of 2024 revealed, or what his efforts were with regard to the court making a finding on heirs?
Okay, as far as heirs, for Linda Garcia Galarza, she had one heir, which was Briseida Galarza. Miss Linda Galarza died while married to Francisco Galarza. Linda Garcia Galarza had never previously been married. However, when Francisco Galarza, who died afterwards, had a previous marriage, and his wife Linda Garcia Galarza predeceased him, he had 3 children. The same Briseida Galarza. He had Francisco Galarza IV, whom Julio Garcia represented, and then a 3rd child, Kayla Vivian Galarza, who we filed her waiver of service on February the 2nd of 2026 on Francisco on 84. I try to keep them by numbers because that's how I differentiate them. And so those are the 3 heirs for Mr. Francisco Galarza and Miss Linda Galarza. It's a mixture where one of the heirs, it's a little bit different. And so that, well, the percentages are different. It's just, so anyway, that's where we have to deal with it. And that's why I don't, as far as determining heirship, the heirship it's very straightforward. It's Linda Galarza, her heirs were her husband and her child, and then Mr. Galarza has the 3 children.
I vaguely remember all of that, but in the court's review, it's just not in the record.
It doesn't show up like on the, like if we go and probably go back to the actual the record itself, like with the court reporters, it'll probably show up. So I'm just going to try to type up something here for Mr. Villafranca to prove up. But as far as all the other orders, because my 2 disinterested witnesses are not mobile, I'm just going to e-file everything without their signature. And that way, when they do come to court, they can sign it in front of the clerk of the court.
All right. Couple of things in either of these estates, and I think in the court's review, has property been sold or administered?
They're trying to sell the property that pertains to Mr. Galarza.
But it hasn't been sold.
It has not been sold. There was an order granting the sale of the property by agreement of all parties. That's already been taken care of. So that's why like that kind of made it seem like to everybody that this case was already resolved. That was just a Band-Aid because the 2 disinterested witnesses are the ones that are maintaining that property and paying the property taxes on it. They are they are Miss Linda Garcia Galarza's parents. And they're the ones that are basically funding their grandchildren's, these houses that are not being lived in.
All right, so let's do a couple of things on both cases. Ms. Rodriguez, give us two dates. Give us a final hearing date and then a dismissal date 30 days after.
Final hearing date and how many days out, Your Honor?
Well, it sounds like Mr. Reyes would like this sooner rather than later, so let's do sometime in March or April.
April, final hearing, April 21st at 10 a.m.,
And give us a dismissal after that.
30 days, Your Honor?
Yes.
May 7th at 10 a.m.
Any objection? All right. I guess, and the court's thoughts on this are, I need Ms. Franca to put all this together, wrap it up. So what I don't want, and what my concern was in the court's review, is that the court has an order allowing the sale of property without an order identifying the heirs.
Yes.
And I don't want any unknown heir to come back and say, you're liable and I'm liable, and probate is the one jurisdiction that the court itself is liable.
Everybody's on the hook. I get that.
Yeah. So let's wrap this up April 21st at 10. And just let Mr. Villafranca know, just prepare something for him if you need to, and then he can come in or sign off on it as he wishes. Anything else on these cases?
On those two cases, no, I have one other case. I think that was also called.
Your The application hearing, do you also want an inventory or a report on the sale of?
Yeah, so that it's clear
The-
if liability is to attach, I just want it to attach on date certain. So if it hasn't been sold, put it in writing.
What I'm gonna do is I'm gonna bring in the two disinterested persons in here person, as well as the person who was granted the ability to sell the property. She is going to be the administrator of both the states, and that's by agreement. Well, one by default, the other one by agreement. And that's the person who is granted and she will physically be here as well. I just want to bring everybody here, so because she needs to sign off on the bond, she needs to sign off on everything, and so because the court never ruled on a bond amount, and so we
Right.
need that, and then that way she can sign it here in court and just wrap up all paperwork here.
All well taken and all good ideas. Let's do all of this on April the 21st in both cases, and that'll conclude at least the hearing dates.
Yes, sir.
All right.
Number 18.
This is John Puig versus Maximo Contreras and MCF Generations and MCF Tex Electric, MCF Tex Inc., cause number 2024 CVH 237C3. Court marks Mr. Tellez present in person. Are you John Puig?
I am John Puig, yes.
Welcome to court, Mr. Puig. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is present in court. Maximo Contreras or any other party, is any other party or person or counsel present on this case? Court marks no other persons present. Court takes judicial notice that service was effectuated on defendants February 21st, 2024. Mr. Tellez?
Yes, Your Honor. We had previously filed a motion for default as well as motion for summary judgment because Mr. Contreras did show up. The court denied our motion for summary judgment. At this point, we have everything filed. We would ask for a final hearing date so I can have my client come in. It's a very simple breach of contract where my client paid a dealer of the kind to install electric generators. He paid the deposit. The contractor came forward with improper generators, never rectified it, never finished it, never gave him his money back, never picked up his equipment. It's basically, he just ghosted him. And so we'd like a final hearing.
Sure.
And I have my witness list would be Mr. Puig and the defendant. There's nobody else needed as far as to prove it up. And the rest is contained in the affidavit. So
Well taken. Two things on this matter. First, Ms. Rodriguez, give us a final hearing date.
How many days out, Your Honor?
March or April.
I have March 17th at 2 p.m.
Is that sufficient time?
that is more than enough.
March 17th at
2 p.m.
so ordered. Second thing, I remember this case and I remember reviewing the motion for summary judgment and I remember the order and it was consistent with the court's finding. I don't, however, recall the default judgment.
No, we tried to default, but he showed up. He showed up when we prepared. We tried to do,
Now I remember why I didn't sign it. Yeah.
okay, so
Yeah.
what happened was we served him, he never showed up. Then we do a motion for default judgment, and then he physically shows up in court. So, and he files an answer or verbally gives an answer. So then I got to do a motion for summary judgment. We do the motion for summary judgment. He never shows up ever again, never reaches out. He gave us his email. He's actually, any electronic filing goes to the email account.
Yeah.
And so,
I recall now. Yes, that's absolutely correct. All right, Mr. Puig, between now and March 17th, keep in contact with your lawyer. He's going to prepare you for your presentation of your case on March 17th at 2. Mr. Puig, do you have any questions for the court?
No, I don't, Your Honor.
All right, good luck to you. We'll see you on March 17th. Any other cases for Mr. Diaz?
No, Your Honor.
It's good to see you, Mr. Diaz.
thank you, Judge.
Have a great day.
Your Honor, that's all.
Thank you.
Other than that, yeah.
Your Honor, may we recall Council Chu and Benavides? They have reached an agreement.
Sure. This is Maria Isabel Rodriguez versus San Francisco Real Properties Ltd, cause number 2024 CBD 86L2. Court marks Mr. Benavides present participating by video conference, Mr. Chu present in person. Maria Isabel Rodriguez is also present and participating by video conference. Ms. Angel is present in person to the right of Mr. Chu. Counsel, go ahead.
Judge, we do have an agreement. I think the parties have agreed that my client, San Francisco Ltd, will refund to Mr. Benavides' client the amount of $500. And then Mr. Benavides will non-suit his claims.
Correct, Your Honor. I spoke to Mr. Chu during this period of time.
All right. The court has heard this Rule 11 agreement. It is stated on the record, agreed to by both sides. These are now, it's a ministerial act at this point. These are now orders of the court. The orders are due honor before.
March 30th by submission.
All right, so just get the paperwork in. I will sign off on it, and that will conclude your case. Ms. Rodriguez, do you have any questions for the court?
No, Your Honor, thank you.
Ms. Angel, do you have any questions?
Sir.
I wish you both very well.
Thank you.
Any other cases for Mr. Chu or Mr. Benavides?
No, Your Honor.
It's good to see you both, counsel. Have a great rest of the week.
Thank you, Your Honor. That's all we have.
Next on Council Charles Dismukes, page 6, number 14.
Harley Davidson Credit Corp. as assignee of Eagle Mark Savings versus Justino Sanchez, cause number 2025 CVF34L2. Are you counsel Dismukes?
Yes, Your Honor. On behalf of Harley Davidson Credit Corp.
Welcome to court, counsel. The court marks you present. You're participating by video conference. Justino Sanchez, are you present?
Not identified.
Court marks Mr. Sanchez not present. Counsel, what is the announcement?
Yes, Your Honor. We had filed a motion to retain. I believe today's hearing was in regards to the dismissal docket of this hearing.
So you're right. We're set for dismissal. So what is Harley Davidson's position?
Yes, Your Honor. Our position is that we need to draft our writ of sequestration. Unfortunately, I was under the impression once the order was signed by the court, it would be sent to the clerk of court and they would go ahead and issue the writ. However, found out that's not the case. I need to go ahead and prepare a writ, have it filed, and then have it issued for service.
Well, true, but has that happened?
That has not happened yet, which is why I've asked to retain the case and would request an additional 30 days to go ahead and get that done. And if not, to go ahead and non-suit it prior.
It's been about 10 months. How long would it take to do all of that?
I request 30 days, Your Honor, just to make sure all the ducks are in the row proceeding. However, if the court wants to set a different time, no objection.
I tell you what, let's do this because this is not the first, the second, or the third time. This is now the
Understood, Your
fourth time.
Honor.
And the fourth time, the response isn't, I've done all the work. The response is, I need more time to do the work that I haven't done over the course of 10 months. So I tell you what, let me do this. Let me make a finding that there is no good cause, reason, or basis for the court to grant the request. The court will dismiss this case and the court's orders will be filed on or before.
March 30th.
All right, so I'm going to file this on March the 30th. I'm going to dismiss this case for lack of any good cause, reason, or basis. However, before I sign that order on March the 30th, if all of this work, the writ and everything has been filed, I'm not going to file that order, and then I'm going to set this for whatever request you then file. So I'm
Understood,
basically
Your
giving
Honor.
you 30 days as you wish to do all of that work. If there's nothing in the file, it'll be dismissed. But any thoughts, questions, or objections on any of this?
None, Your Honor.
All right. Any other cases for counsel or for Harley Davidson? All right, I'll review this case on March the 30th. I wish you well.
Thank you, Your Honor. May I be excused?
Yes, sir. Have a good day.
Thank you. You too.
Next online is Counsel Karen Kish. I'm not sure what case she's here for.
Counsel, what case are you here for?
You're on mute.
The Mumati case.
Page 3, number 7, you're on.
This is in the estate of Mudari, cause number 2025 cause number 2005 PB588L2. Counsel Kish, who are you here on behalf of?
I'm here on behalf of Ramchandar Mumati, the applicant.
Counsel Kish, the court marks you present and participating by video conference. Are you Jacob Flores?
Yes, Your Honor.
Counsel, who do you represent?
I represent Sai Mumati. He's an heir of Pradyuma Mumati.
And are you Saeed Mari?
Yes.
And this is your lawyer, Mr. Flores?
Yes.
Court marks you both present and participating by video conference. Are you Ramchandar Mumtari?
Yes, sir.
Welcome to court. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Counsel Kish, what is the announcement?
Your Honor, Mr. Flores filed a motion to allow us to open up a safety deposit box.
Counsel Flores, go ahead.
Yes, Your Honor. I filed a motion on behalf of my client, Sai Mumati, to open safety deposit box and examine papers with two separate banks in Laredo, Texas, where we believe there may be a will for the decedent. And I can call my client with your permission to provide testimony to that.
You may, but have you had an opportunity to talk to Counsel Kish about this?
We've discussed it briefly. If no will is found, we are also in discussions towards having a third-party administrator appointed and stipulating to heirship.
Having spoken and conferred with Counsel Kish, is it your impression that there is an agreement or a disagreement to the request?
As far as my understanding is that we're in agreement to the request.
So this is ostensibly just a prove up.
Yeah, I suppose so.
All right. Let me ask both parties to raise your right hand. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Both have answered yes. You may lower your hands. Mr. Flores, take your first witness.
I'd like to call Sai Mumati. Mr. Mumati, please state your full name for the record.
Sai Chandar Mumati.
And what is your relationship to Pradyuma Chari Mumati?
I am his second son.
And is it true that Mr. Pradyuma Chari Mumati is deceased?
Yes.
And when did he pass away?
He passed away on November 20th, 2025.
And at the time of his death, where did Mr. Mumati reside?
He resided in Laredo, Texas.
Was Webb County, Texas, the county of his domicile at the time of his death?
Yes.
And then do you have reason to believe that the decedent maintained a safe deposit box at Bank of America?
Yes.
And where is that Bank of America branch located?
It's located at 5313 San Dario Avenue, Laredo, Texas 78041.
Okay. And why do you believe that the decedent maintained a safe deposit box at that location?
Because my father, like usually, like I believe that he wouldn't keep important stuff inside the house. So I believe he must have maintained a safety deposit box. And also he maintained a safety deposit box in the past before he moved to Laredo.
Do you believe that the safe deposit box may contain the decedent's will or other important estate documents?
Yes, because if he kept a safety deposit box, there must be important stuff in there.
Do you also have reason to believe that he may have maintained a safe deposit box at a Wells Fargo?
Yes.
Where would that Wells Fargo be located?
5219 San Dario Avenue, Laredo, Texas 78041.
Okay. And do you believe that that safe deposit box may also contain any of the decedent's will or other important estate documents?
Yes.
And why do you believe that it may be at that location?
Because in the past, my father had a safety deposit box at Wells Fargo before he moved to Laredo. So I'm certain that he might have had a safety deposit box at the bank of Laredo as well.
And what is the purpose of requesting the court to order to opening the examination of these safe deposit boxes?
To locate the decedent's will, if one exists, and any other documents with insurance policy so the decedent's estate will be distributed properly.
Have you been able to locate a will for the decedent through any other means?
No.
Are you willing to serve as the court's representative for the purposes of examining these safe deposit boxes?
Yes.
Do you understand that the examination must be conducted in the presence of the judge or a judge's agents and/or an officer of the respective bank?
Yes.
And do you understand that you may only remove items from the safe deposit box as specifically authorized by this court's order?
Yes.
No further questions, Your Honor.
Cross-examination, Ms. Kish.
No, Your Honor, we're fine.
Mr. Flores, any other witnesses?
No, Your Honor.
Ms. Kish, do you have any witnesses?
No, Your Honor, I just do want to ask that since these brothers are not in agreement with a lot of things until we get this settlement done, that a third party is involved with going through the safety deposit box.
Do you have a suggested, well, first question to Ms. Kish, do you have a suggested person?
I don't, because no one lives in Laredo. I don't believe Cy lives in Laredo either, so I don't know how this is going to play out. Mr. Flores, do you live in Laredo?
Give me 1 second. No, well, according to his pleadings, I think he's in Houston. Mr. Flores, give the court a response to Ms. Kish's request for a third party.
No objection to a third party being present, Your Honor. I believe my client is willing to travel to Laredo if need be. If we can arrange for a third party, that would probably be best for everyone.
A second question to you, do you have a suggested person?
No, not this time, Your Honor. My client's willing to travel to Laredo to be present with a bank representative. That would be a third party that would be present with the court order in place limiting any removal to a will. I would think that would be some level of protection.
Couple of, well, more questions now. Mr. Flores, by reviewing your pleadings, I'm ascertaining, but I don't want to presume. You're in Harris County?
I myself am located in Travis County. My firm has office in.
And Ms. Kish, what county are you in?
I'm in Harris County.
Where well, it's not going to matter because you're in different counties. But let me give you some thoughts and some options. But first, as to this motion, it's not opposed and it's testified to. The court finds that there is sufficient information in the record to permit the court to grant the request. The court hereby grants the request. First thing with regard to that order, Mr. Flores, the order only specifies Wells Fargo and listed as a respondent and also doesn't list Bank of America. And I think the request and testimony supports both. So let me give you an order's due date for that amended order. that amended order is due to the court honor before.
March 30th by submission.
Now, before you file it, send it to Ms. Kish or whatever applicant's counsel. I think Ms. Karen Keeley may also be a recipient. So send it over, and if it's agreed to sign off on it. If it's not agreed to, then file it with a counter proposed order. Now, with regard to this person, I think that that's a good idea, because if neither counsel is here and neither of the parties are present, then that's probably a good idea and in the best interest of openness, transparency, and in the best interest of this estate. So let me give you a couple of options, or let me give you three options, and let me hear from each of you. The person already doing work, or should already be doing work on this case, the court's appointed attorney ad litem, is counsel Gabriela Garcia. She was appointed January 6, 2026. She may be familiar with the facts, although I don't want her then becoming a witness, number one, but that's an option. Number two, I guess the court could appoint the senior district judge, who then the court may also appoint in the future if it becomes necessary as a mediator in this case, since you're in different counties. Or three, the court could just take the very next person, the very next lawyer on its, I don't call it wheel here, but it's called wheels in other counties. So just the next probate court attorney. Let me get your thoughts as to these suggestions, Mr. Flores.
I have no objection to any of those suggestions. I think it may be the most efficient and cost efficient to just use the next appointed ad litem if we're not wanting to create a witness of the current one.
And your thoughts, comments, Ms. Kish?
I agree with Mr. Flores. I think that's the most judicious choice.
All right, then there is an agreement. So I tell you what, in your proposed order, Mr. Flores, send it over to Ms. Kish with a blank, as just agreed to the language. When the court receives it, whatever date that lands on, I will pull the court's list and just appoint the next person. That person should then, and you should write this in the language, in the order, that person should then communicate to each counsel what proposed dates work. That way, if your clients choose to be present, they may choose to do so. Any thoughts, comments, objections to any of this, Mr. Flores?
No, Your Honor.
Ms. Kish?
No, Your Honor.
All right, these are the orders of the court. The orders are due on or before March the 30th. As soon as they come in, I will sign off on them if agreed to. If not, I will consider the objections. Mr. I was going to say your last names, but you have the same last name. Mr. Ramcharder, do you have any questions?
No, sir, I do not. I just would like to add that I am in no objection of traveling as well. I live in the state of Georgia. I would just ask for just a little bit of discussion to be involved with if we would be able to do this together, as well as have a third party, whether it's a litigator, sheriff's office, or anyone in that manner to be present.
This is a good observation, sir, because what the court has indicated is that Mr. Flores in his proposed order is going to put in language that sets a date in the future so that if you choose to be present, you could, but you don't have to. Same thing for Mr. Saeed. He could choose to be present, but he may choose not to be, but at least you're given the option to do that.
Yes, sir.
Mr. Saeed, do you have any questions for the court?
No, Your Honor.
All right, I ask that you both keep in contact with your lawyers. But we're still pending. Now, other than that, is this case ready to be heard?
No, Your Honor.
All right, so it's going to go inactive until then. Once you fill out the court's checklist to affirm that all the requirements have been made, then we'll set, because I don't want to set it in 2 weeks. It's not going to be ready. I don't want to set it in 3 months if it's not going to be ready. So whenever it's ready, just file that advisory with the court and we'll set it for hearing. And I'll sign off on the orders as soon as they come in. Anything else on this case, Mr. Flores?
No, Your Honor.
Ms. Kish?
No, Your Honor. Thank you.
I wish you all very well. Have a great rest of the week.
You too. Thank you.
Next on line is Council Victor Gonzalez, page 6, number 13.
Miri Castillo versus Allstate Vehicle and Property Insurance Company, cause number 2025 CBF 57L2. Good morning, Mr. Gonzalez.
Good morning, Judge.
Court marks you present, participating by video conference. Counsel Sandoval, Rosemary Conrad Sandoval, are you present?
Your Honor, she was present, but she had an emergency. She texted me. But yeah, we filed the pretrial motion yesterday. It should already be filed. It was. We were just going to show up today to announce that, Your Honor.
And this is a request for dismissal?
Yes, Your Honor.
The court has received, reviewed, and considered the request for dismissal and its accompanying agreed to order. It is in due form. The court has signed it and tendering the original signed copy to the clerk's office. Any other cases for Mr. Gonzalez or Mr. Polker?
No, Your Honor.
It's good to see you, Mr. Gonzalez. Have a great day.
Thank you, Your Honor.
No, my apologies. Yes, page 7, number 16 for the pretrial guidelines.
Mr. Gonzalez, Alma Martinez versus Allstate Texas Lloyd's, cause number 2025 CBF 82L2. Mr. Gonzalez, are you still present?
No longer present in the virtual world.
Is there a pretrial guideline order?
Yes, Your Honor, it was just filed this morning.
Okay, there it is. Has the court had an opportunity to check the dates?
No, Your Honor.
So I tell you what, let me pause on this and set it for one more calendar call pending the approval of those dates. Calendar call will be held on
April 21st at 10 a.m.
all right. That date will be eliminated as soon as the court signs off on that pretrial guideline order.
Next online is Counsel Kelly Ferguson. No longer. Oh, sorry.
Present, Your Honor. Kelly Ferguson, I'm here for Home State County Mutual Insurance for the plaintiff. Defendant is Jorge Neri Jr., 2025 CVF 33L2.
Page 6, number 15.
Home State County Mutual Insurance versus Jorge Neri Jr., cause number 2025 CVF 33L2. Good morning, Ms. Ferguson. Tell me once more who you represent.
I'm here for the plaintiff, the insurance company.
Understood. Welcome to court. The court marks you present. You're participating by video conference. Jorge Neri Jr., are you present? Court finds defendant Neri not present, and the court takes notice that he was served with process April 16, 2025. Ms. Ferguson, what is the announcement?
Your Honor, we're here on a motion for default judgment that has been filed with the court in November of 2025 with a notice of today's hearing issued on February 11th of 26.
All right. And what would you like to argue and for the court to consider?
Yes, Your Honor. I asked that a petition was filed April 3rd of 25, as you mentioned, service April 16th of 2025, the default judgment November 4th of 25, and notice given in February of 26. I asked that the court take judicial notice of the file regarding this case. Included in it is the business records affidavit. This was a car accident, and the defendant is now liable for the injuries and damages caused by that, which totals $65,422.51. So we're seeking judgment for that amount plus costs of court of $437.50 and post-judgment interest at the statutory rate of 6.75% per annum.
All right. Anything else?
No, Your Honor.
In cause number 2025 CVF 33L2, the court at this time finds that it has jurisdiction over this matter. The court hereby takes judicial notice of the entire case file, which includes the original petition, the original citation, the return of service that was executed back in April 16th of last year. There is a request and a motion for default judgment. The court has received, reviewed, and considered that, including all of its accompanying documents, which includes the business records affidavit, the certificate of last known address, the non-military affidavit, and all of the contents of the court's file. The court finds that plaintiff is entitled to the relief it is seeking. Judgment hereby is taken for plaintiff and against defendant in the amount of $65,422.51. No prejudgment interest. Cost of court are $437.50. Filing fees, process server fees, and post-judgment interest as allowable by law. The court has received and reviewed and considered the final default judgment. It is in due form. The court has signed that original and tendering the original signed copy to the clerk's office. That now concludes this case. Anything else on this matter, counsel?
Nope, and that is all I have. May I be excused?
Have a good day. Yes, ma'am.
Thank you as well.
Next online is Counsel Guadalupe Canales, page 5, number 11.
Laredo Housing Authority versus Armando Samaniego Jr., cause number 2025 CVD 8302. Ms. Canales, are you present?
Yes, I am, Your Honor. Good morning.
Good morning. The court marks you present and participating by video conference. Mr. Miller,
Judge,
are you here on this case?
I am, Judge. I represent Laredo Housing Authority.
Welcome to court, Mr. Miller. The court marks you present.
Thank you,
by
Judge.
video
Appreciate the warm welcome.
conference. Court marks both counsel present. Welcome to both. Armando Samaniego Jr., are you present?
No, Your Honor.
All right,
He's
this is
not.
a docket control conference. Counsel, what is the announcement?
My counsel, my attorney, I'm sorry, my client, Mr. Samaniego, has vacated his unit. He wants to dismiss this appeal, and he's asking the court for an order for the voluntary dismissal of his case. He no longer has any interest in following this appeal at all. And I submitted an order for the court's consideration and the notice of the voluntary dismissal. This is an appeal from the JP Court of an eviction case.
Mr. Miller, have you had an opportunity to review those documents, the request for dismissal and the order?
I have not, Your Honor, but my understanding is that Mr. Samaniego is still in the possession of the property, according to my client representative. So we do need to keep this case on the docket at this time until I can confirm otherwise, as our JP Court judgment, of course, went away upon their appeal. That was done back in September of 2005. Or 2025, excuse me.
I'll go ahead and confer with my client. I mean, he did advise me yesterday, or rather about Monday, that he was not gonna, that he had vacated his unit.
Your Honor, if I may, even if the issue of possession is moot, there's still the issue of back rent that would need to be considered as well. I'm happy to confer with Ms. Canales, but her filing of a motion yesterday to dismiss this matter, I think, is one, untimely, and two, it's not well founded because there is still a pending matter here to be brought before the court. What we're here on today is a docket control conference. That's my understanding according to the notice of setting. And so all we're here on from the plaintiff's perspective is to get a trial setting.
Well, this is supposed to be relatively straightforward, and I think we all have managed to complicate it more than necessary. So let me ask you, so let me unravel this. One, Counsel Canales has filed a request for dismissal, which is not a non-suit, so it's not automatic. One. Two, remind the court, if this is an appeal from a justice of the peace court?
Correct.
Yes, Your Honor.
Who was the plaintiff in that case?
My client, Laredo Housing Authority.
And who prevailed in the underlying case?
My client, the Laredo Housing Authority.
And ostensibly then, Ms. Canales, your client is the person that appealed this case?
Yes, Your Honor.
All right.
You know,
And
if we have
as part of that appeal, you filed a bond and all these things.
Judge, I'm sorry to interrupt, but I would ask the court to take judicial notice. There is no bond. They filed an affidavit of inability to pay.
All right, notice so taken. Now, in this case, since it's a trial de novo, Mr. Miller, has Laredo Housing Authority filed a counter petition? I'm sorry, you're the original.
Correct, Judge.
But if the non-prevailing party is no longer proceeding, then the whole thing gets vacated and you go back and you stand on the original judgment, do you not?
I don't believe that that's true and accurate, Judge, especially when the original court's power, plenary power, has since dissolved. This case was, I believe, appealed in September of 2025. And so my client, I think, does need to go and get a final judgment from this court because the appeal was de novo, and they perfected their right to appeal. The appeal's already perfected and the court has lost jurisdiction. The lower court has lost jurisdiction.
So I guess let me ask you this. When a non-prevailing party appeals a justice of the peace case to a county court at law and then abandons their appeal, what is supposed to happen in that scenario?
I got to go forward and get a judgment because my judgment went away as of the timing of the perfection of the appeal. Unless we can come to terms on some sort of an agreement for move out or can confirm. I'm not here to try to force them to continue their appeal, but I'm not sure that it's appropriate for the court to just go and dismiss their appeal, quote unquote, voluntarily on 1 day notice first, and two, when there is a dispute as to who is still maintaining possession of the property.
No, I don't disagree with any of that. I'm just trying to figure out procedurally what the best outcome is and what it should be. So I tell you what, we're set for a docket control conference. So Mr. Miller, Ms. Canales, have you conferred on dates?
We have not, Judge.
All right, Mr. Miller, how much time do you need to prepare for a final hearing?
I think he got frozen.
And of course, I've lost you.
Yeah. Mr. Miller, one more time, how much time would you require to present this case at a final hearing?
Oh, Judge, this is a traditional non-payment case, 30 minutes maximum.
Sorry, would you like a setting in 30, 60, 90?
Oh, I apologize. I misheard the question. My internet connection was spotty. Judge, I think 30 days, it's not a complicated matter. And again, I'm happy to confer with Ms. Canales in the meantime to see if we can reach resolution.
Ms. Canales, any objection to a final hearing in 30 days?
No objection, and I'm willing to confer with Mr. Miller regarding this case.
Well, and that is independent of who owns and who possesses and who filed what yesterday. That's the purpose of our setting today, to set it for a final hearing. Ms. Rodriguez, give us a final hearing date as close to 30 days, 30 to 60 as possible.
April 7th at 2 p.m.
Any objection to that date, Mr. Miller?
I have none, Judge.
I'm sorry, what's the date?
April 7 at 2 p.m.
That's fine, Your Honor. April 7th.
All right.
At 2 p.m.
Hopefully you'll reach a good resolution before then. If you don't, I'll make a decision based on the evidence and testimony. Any other cases for Mr. Miller or Ms. Canales?
No, Your Honor, no final pretrial before the final hearing.
No.
Okay.
Good to see you.
Thank you very much, Judge.
Have a great day.
Thank you,
You too.
likewise.
Bye-bye.
Line is counsel Sarah Dunn, Your Honor. I had sent a notice of setting for this cause number 2026 PB7 000002L2 in the estate of Sherry Gale Voles, but inadvertently did not open it for the docket.
Understood. Sarah Dunn, are you present?
Yes, good morning, Your Honor.
Good morning. The court marks you present. You're participating by video conference. I'm going to ask that you unmute your device and tell the court, are you Donnelly Smythe?
Yes, sir. I am Donnelly Smythe, also known as Donnelly Petrie.
Welcome to court. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Ms. Smythe, who is the person on your left?
She is my attorney.
Good morning, Your Honor. Janisa Richardson. I am Miss Petrie's Washington attorney, and her husband, Gerald Petrie, is also in the room with us, Your Honor.
Court marks Ms. Richardson present by video conference and Mr. Petrie also present by video conference. Welcome to all. Is there any other person, litigant, witness, or attorney present on this case?
No, Your Honor.
Ms. Dunn, what is the announcement?
It'll probably take like 5 minutes, and it is an application for letters of ancillary probate.
All right. And are you going to call Ms. Smythe as a witness?
Yes, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
You may lower your hand. Counsel, go ahead.
Good morning, Ms. Petrie. Petrie, may you please state your name for the record?
Donnelly Petrie.
Were you also formerly known as Donnelly Smythe?
Yes, ma'am.
And what is your relationship to the decedent Sherry Gale Voles?
I was her daughter. She was my mother.
And when did Mrs. Voles die?
March 10th of 2025.
And have 4 years passed since the date of her death?
No, ma'am.
Where did Mrs. Voles die?
She died in Ferndale, Washington, in Whatcom County.
And was she residing in Whatcom County, Washington on the date of her death?
Yes, ma'am.
Is it correct that Mrs. Voles's will, dated September 21st, 2022, was admitted to probate in the Superior Court of Washington in Whatcom County in the state of Washington?
Yes.
And her will was admitted to probate by order admitting will to probate, appointing personal representative, and granting non-intervention powers. And that order is dated March 21st, 2025. Is that correct?
Yes, ma'am.
And were you appointed as the personal representative of Mrs. Voles' estate by that order?
Yes, ma'am.
And do you continue to serve presently as the personal representative of Mrs. Voles' estate?
Yes, ma'am.
And have authenticated copies of Mrs. Voles' will and the order been previously filed with this court?
Yes.
Did Mrs. Voles have an interest in or own any property in the state of Texas on the date of her death?
Yes, she did.
And what did she own? Was it real property?
Yes.
And is the real property located in Webb County, Texas?
Yes, ma'am.
Does Mrs. Voles' will affect the real property located in Webb County, Texas?
Yes.
Is there any reason why you would be disqualified from serving as independent executor in the state of Texas?
No.
Have you ever been convicted of a felony?
No, ma'am.
Okay. I pass the witness, Your Honor.
I don't know that out-of-town counsel is licensed, but I'll give you an opportunity to be heard. Is there any other person that would like to be heard on this case?
Your Honor, the state of Washington attorney is not participating. She's just with the client, helping her with the Zoom and everything. So
that's exactly what I just tried to say without actually saying it that way. But yes, well taken. Well taken. All right. Anything else on this case, Miss Dunn?
No, I believe not, Your Honor, unless you have anything further.
No, I think the court has heard sufficient information, and there is sufficient information in the record to grant the request. Ms. Petrie, in your mother's case, cause number 2026 PB7 2L2, the court at this time finds that it has jurisdiction over the case, meaning this is the proper court form and venue to consider your application to probate your mother's foreign will in this county. The court takes judicial notice of the entire case file. which includes that application, the affidavit of attestation, and that Whatcom County Superior Court certification and order. The court also sees that you have the appointment of resident agent, the order admitting this foreign will. That's the proposed order in the file, the citation by posting, the order admitting the foreign will to probate. And the court now also has heard your testimony here. The court finds that your mother passed away on the 10th day of March 2025 in the state of Washington, having left a valid, proven, and executed will that was admitted into probate there. The court finds that you were you were appointed to serve as her personal representative of her estate. You continue to serve. The court finds that your mother has real property in Webb County, Texas. The court finds that you are qualified and you are not disqualified from serving. For all of these reasons, the court finds that you are entitled to the relief you are requesting. The court hereby admits your mother's will into probate in this county. The court is signing that order filed by your lawyer.
Thank you, Your Honor. And Your Honor, will the court require like the filing of an inventory or affidavit in lieu of thereof, and just basically all of the same filings as usual?
Yes, let me give you those dates. Inventory is due on or before
June the 9th at 9 a.m.
Okay.
All right. Anything else, Ms. Rodriguez or Ms. Rodriguez?
I have nothing further, Your Honor.
All right. The court has granted your request. Ms. Petrie, do you have any questions for the court?
No, sir. Thank you, Your Honor.
You're certainly welcome. You have the court's condolences. Anything else on this case, Ms. Dunn?
No, Your Honor. May we be excused?
Yes, I wish everyone well. Have a good day.
Thank you. Likewise. Bye-bye.
Page 2, number 4.
In the interest of Andres Castillo, cause number 2025 PB454L2, Mr. Andres Reyes, are you present? Andres Castillo Jr., Devana Price, any other persons present on this case? Court finds no persons are present. There is a request for continuance. It is well taken. The court is signing that order.
Your Honor, may I suggest we await for their motion to set on this cause?
Yes, the court will set this case to inactive until the request is filed. So ordered.
Thank you, Your Honor. Page 7, number 17.
Maria Elena Martin Angel Gabriel Martin versus Aaron Gallegos Griselda Lara, cause number 2025 CVM 71L2. Juan Jose Garcia, Ralph Rodriguez, Thomas Parker. Are any lawyers present on this case?
I'm Mr. Rodriguez's paralegal.
Are you licensed to practice law in the state of Texas?
No,
Are you
he's
making an appearance before the court?
yes.
Can you make an appearance before the court?
Well, I logged in because he's in a expert depot. I just didn't want to miss the DCC. Let me see if I can.
So there is no one present on this case. Any parties present?
No, Your Honor, not identified online or in person.
All right. Court finds that there are no persons present on this case. Give us 2 dates. Give us a docket control date.
How many days out, Your Honor?
30 to 60.
April the 21st at 10 a.m.
And give us a dismissal setting.
May the 7th at 10 a.m.
All right. So what this means is that the parties should file in their proposed pretrial guideline order on April the 21st. And if no persons are here on that date, then on May the 7th, the court will hold a dismissal setting. All right. Thank you, Ms. Benavides. We appreciate your presence.
Thank you.
Cases have been called, Your Honor.
May I be excused?
Yes, have a good day. All right, all cases have been called. This now concludes this docket held in person and by video conference for Thursday, February 26, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, like our probate court investigator, the county clerk's office, and the sheriff's office. The court appreciates you all. Have a good day.